Yes, people, let's quickly do 7 to 9. I think you guys have written. It was a pretty small paper for 7 to 9. It was hardly, I think, 12 marks that was covered overall, though it was 3 questions. But okay, nonetheless, we will see. Sahil sells by auction to Rohan a horse which Sahil knows to be unsound. The horse appears to be sound, but Sahil knows about the unsoundness of the horse. Is this contract valid in the following circumstances? They are giving you circumstance. What is that? If Sahil says nothing about the unsoundness of the horse to Rohan, is this contract valid? I know that the horse I am selling you is not right, but I still sell it to you without disclosing anything. Is this contract valid? Is it valid? Voidable? Valid? Fraud? Section 17? Fraud? Abbas, valid or what?
A is void. Void.
Void. It's valid or void? Void. Voidable. You guys have to be very clear in using the word. Is it voidable? Is it void? Is it valid? It's voidable.
Only mistake is void. Section 20 to 22.
Correct. Now this one is voidable.
So section A is valid.
This is valid. Why, Abbas? Why is it valid?
Because I've written seller is not generally obliged to disclose.
Perfect. Right answer. Oh, this is not fraud. Why? Hey, in class 100 times I told you. I'm not. Hey, I will not tell this to Ramana that this mic is not working. I will sell it to him. Is it fraud? I told you it is a duty of the buyer to check. You should also check. You should also make your own inquiries. Hello? I am not under an obligation to tell everything. Seller is not under an obligation. Mere silence does not amount to fraud. We wrote that also. There is only 2 exceptions. What are the 2 exceptions? When does silence amount to fraud? When you have a duty to speak. When silence is equivalent to an acceptance. Hello? Okay. If Sahil says nothing about it to Rohan, who is Sahil's son?
Voidable.
Now what is the scenario? What is happening? If Sahil says nothing about it to Rohan, who is Sahil's son? So Sahil is selling it to Rohan only. Rohan is Sahil's son. And I know it is unsound. And I am still not disclosing anything. Now is it fraud or not?
No.
It is not fraud.
It is a relationship between father and son.
Huh.
It is duty to.
So is it void, voidable, valid contract? Is it fraud or not?
Voidable.
It's voidable. So it's fraud. What is the provision? Section 17, fraud, where mere silence amounts to fraud. Mere silence is not fraud. In that exception, you will be seeing people, what? You would have seen something called as fiduciary relationship. A father cannot lie to son. He cannot keep it silent. So it does amount to fraud. That is a place where you have a duty to speak. Hello? Yes or no? Extra gyan karke in PDF there was something in that this example also was there. Illa. Okay. If Rohan says to Sahil, if you do not deny it, I shall assume that the horse is sound. Sahil says nothing. Is it fraud? Is it fraud or not? Is it fraud? And say like this. If it's not fraud, say like this. Is it fraud? Yes. Why? When I have clearly asked you a question, if you do not reply, then I will think it is fine only. I have asked you, you have a duty to speak. Now silence is equivalent to speech. When you do not reply, I've clearly said, then I will think it is fine. If I said that and if you do not reply, it will amount to fraud. So in the given 3 cases, the first one is not fraud. The second and third one is considered as fraud. Section 17. Provision will be section 17 of Indian Contract Act, and you will be writing what is fraud, and you will also be writing does silence amount to. Silence does not amount to fraud. However, this rule has exception. One is duty to speak. Next one is mere silence is equal to acceptance. Is considered as speech. So quoting that I will be writing. Clear? So when I clearly say, when that is the scenario, then you have to go with that. When I have clearly asked you, you have an obligation to speak. Agreed, huh? Yes, Sam. I don't know how many of you are realizing all these questions we have seen in class only as example. Yes? Okay. Mr. Vikas, a businessman, has been fighting a long drawn litigation with Mr. Neeraj, an industrialist. To support his legal campaign, he enlists the services of Mr. Manoj, a judicial officer, stating that the amount of rupees 10 lakhs would be paid to him if he does not take up the brief of Mr. Neeraj. Mr. Manoj agrees, but at the end of the litigation, Mr. Vikas refuses to pay to Mr. Manoj. Decide whether Mr. Manoj can recover the amount promised by Mr. Vikas under the provision of Indian Contract Act 1872. Now, why I say this question is good and tricky, because the question is drafted in a very complicated way. They've used the word like brief. They've used the word like judicial officer. So, remember, at times they can use in your exam, they can use certain complicated languages. Take some time and try to understand the scenario in such cases. Don't just focus on those words. Now, what is happening in this case? Mr. Vikas, a businessman, has been fighting a long drawn litigation with Neeraj. Vikas and Neeraj are fighting a case. An industrialist. To support his legal campaign, he enlists the service of Mr. Manoj, a judicial officer, stating that amount of 10 lakhs would be paid to him if he does not take up the brief of Mr. Neeraj. What is Mr. Vikas telling? He is going to one officer, judicial officer. That means, imagine he is a lawyer, advocate. I'm going and telling him people what? I'm going and telling Manoj, you should not take up the case of Mr. Neeraj. Yeah, you should not, when he comes to file any case, if he wants to come for help, you're not supposed to take up his case at all. And I am paying for this, I'm paying you 10 lakhs. Now, whatever I did, now because I entered into a contract with Manoj did not take up the case. After that, people, he is asking for 10 lakh, Mr. Vikas did not pay it. Now they are asking you, can Mr. Manoj recover the money? Now, under what grounds he cannot recover? What is the provision? First thing, it comes under unlawful object, unlawful consideration. That's the main heading, a provision. Under that, you saw agreements that is opposed to public policy. Agreements opposed to public policy. So, if you remember, last one, agreements opposed to public policy. Under that, we started writing another branch. There it will come interference with course of justice. You cannot bribe the lawyer. You cannot bribe the witness. You cannot bribe the opponent lawyer. You cannot bribe the officers. Why? Because of that, the case is not going the way it can go or it has to go. So based on that, this type of contract is considered as opposed to public policy. So hence, whether Mr. Manoj recover the amount, conclusion, referring to my facts and provisions, Mr. Manoj will be unsuccessful in recovering the amount, as this is a contract which is opposed to public policy.
So it is void, right?
It's void. Hello? Yes, sir.
So as you been official authority, we can't.
It is interference in the course of justice. So you cannot stop the case from going in the way it has to go. You cannot stop it.
Stifling, right?
No. That is criminal cases. This is any case.
Other than criminal cases.
See, stifling of prosecution and what is that? Interference in the course of justice. What is the difference between these two? Stifling of prosecution is nothing but settling of criminal offences. You cannot. Death, someone killing, robbery, theft, you cannot compromise them. You have to come to court. If you compromise it, that point comes under stifling of prosecution. Interference in the course of justice. The opponent lawyer will be purchased by giving 5 lakh rupees. I will give money to witness. I will tell don't come to court tomorrow. I'll give 1 lakh rupees to the judge. I'll tell him don't, pass the order in the favor of the other person. I'll give you 1 crore. That is called interference with the course of justice. That's the difference between stifling of prosecution and interference with course of justice. Clear? Huh? Hello? Yes or no? Okay. Next one, examine the validity of the following agreements under provision of Indian Contract Act 1872 and justify your answer. See, this is what I told you. They can ask you one main question. So ninth question, under that they can ask you 5 questions also. And they're asking weightage is 7 mark. So it will technically be like this, 2 plus 2 plus 2 plus 1. Getting the point? That is how this weightage will be. Now when I'm writing it, we'll see whether they all belong to the same provision or different provisions. Getting the point? Okay. Miss Priya pays a sum of 10,000 to a marriage bureau to provide information about the prospective grooms for her daughter's marriage. What is the question? Examine the validity of the following agreements. Is it valid, invalid, void, voidable? What is it? Void. This is void you are saying. Marriage brokerage agreements, they are void or valid? Void. Yes or no? This is a valid agreement. Read carefully. Miss Priya pays a sum of 10,000 to a marriage bureau. Shadi.com.
It's not brokerage.
Yes, sir. Shadi.com. I told you it's not a marriage brokerage. Bureau is what? Data. Is it void? No, it is a valid agreement. Only marriage brokerage agreements are invalid. But in the case of marriage bureau, they just supply the data. Now, what is that? Correct. Now, Ashmita has a question, sir. How will we know all that in the exam? That's why, if you ask me, the examiner is in favor of you. I tell you this 100 times. The question will have hints. Read fully. Miss Priya has paid a sum of 10,000 to marriage bureau for why?
To provide information.
To provide information about the prospective groom. Nothing they have said for marriage, no. And then, is it a valid agreement, void agreement? Valid agreement. So how I'll write? Provision, conclusion.
It's no fact.
No fact, not required. Now how will I write? My question will start with like this. See, 1. Miss Priya pays 10,000 to marriage bureau and about cross relevant section, no? Section 10 and 23. Okay, an agreement is void if it involves an object that is against public policy. In the given case, people offering does not contravene public policy. Therefore, the agreement is valid and Miss Priya has entered into a valid enforceable contract. So, provision, conclusion. Provision, conclusion. Like that you have to write 4. Why are we following it this way here? The reason is they do not share a common provision. Maybe it will be different for the rest of it. Understanding? Okay, what is the next one? Bharat agrees with John to sell his white bull. Unknown to both the parties, the bull was dead at the time of agreement. Is it a valid agreement or what? Void? Void agreement, voidable agreement, voidable contract, what? Void agreement? Okay, what is the provision? Mistake? Mistake of fact. Unilateral, bilateral. So you guys have to write completely. Bilateral mistake of fact. It will be considered as void. Understood? Same scenario we saw in class also. The dog. That is when the Satish person came. Rishabh sells the goodwill of his shop to Omkar for 10 lakh and promises not to carry on such similar business within the local limits so long as Omkar carries on like business. Is it a valid contract or void? What do you think? What is it? Rishabh sells the goodwill of his shop to Omkar. That means I've sold my shop to Omkar for 10 lakh. And I've promised him not to carry on such similar business, same business, within the local limits so long as Omkar carries on the like business. Meaning as long as you are doing this business, I will not carry on this business. If it is 8 years, 8 years, 15 years, 15 years, 50 years, 50 years, I will not carry on a similar business. Is it reasonable? Is it valid or invalid?
Invalid.
Invalid? Invalid? Why?
Valid.
First of all, what is the provision?
Exception.
Agreement in restraint of trade.
An exception, the goodwill of.
Okay, so is it valid, invalid? It's okay, confidently say invalid. Why is it invalid?
Reasonable.
It's not reasonable. Okay. Abbas, why are you saying it is valid? Meaning what provision you wrote?
That exception to the goodwill of business. So it is restraint of trade. So it is valid.
So it's valid. So you're saying you can stop someone from doing business. Imagine if I'm doing this business for 20 years and you will also not do the business for 20 years. Is it valid?
So the year is not.
Until I do it.
So it is invalid. Accordingly to the restraint of trade, he sold his shop to Omkar for the rupees 10 lakh. Then he told that on the grounds, in the surroundings, I will be not carrying the similar business. But he did not mention any year, that is up to 1 year, up to 2 years. Did not mention any of it.
As long as he carries the similar. Now, so is it reasonable? When you start a business, do you start it with the mindset I'll do it for 3 years, or you will always start it with the long term? So imagine if you're doing it for 5 years. That means 5 years I cannot do similar business. 10 years I cannot do similar same business for 10 years. 15 years I can't do. Why I'm telling that, remember people, most of them will write this restriction is what? They will write unreasonable and they will say it is agreement in restraint of trade. If you ask me people, this is a valid restraint of trade. Why? The reason is people, what are they telling you? Rishabh sells the goodwill to Omkar and promises not to carry on the similar business within local limits.
Only on local.
People in the entire country, I'm telling you, don't do the business in this place called Koramangala. Can I go and do it in Jayanagar? Can I go and do it in Majestic? Can I do in Electron Day? Okay, can I work at a Bangalore Bitpidre? Can I do it in Mysore? This is not a restraint of trade at all. It's a reasonable restriction. I told you 2 things you have to evaluate. I don't know why none of your brains worked on area here. All of you are saying time. Why did you skip the area part? They are just saying only local area. Did I say in the entire country? So it's a reasonable restriction. Hence it is valid. Agreed? Hello? Okay. A property worth 2 lakh was agreed to be sold for just 25,000 by a person of unsound mind. Is it a valid contract? No. Why they are telling you? Remember, there are chances people will write 2 answers here. One people will write, it's a valid agreement. You know why? They will write, the consideration need not be adequate. They will think that is the answer. Because they are telling the property worth 2 lakh is being sold for 25,000. So consideration need not be adequate and hence the contract is valid. People may write that. But what is the right answer? Competent parties, as long as the person is unsound mind, consideration is irrelevant. So the competency matters a lot. Because the person is unsound mind, the contract is, the agreement is void. It's a void agreement.
When he's unsafe, he can't go to the contract.
Correct. So that's why they have clearly said unsound mind. So I will assume he is unsound mind and the contract, the agreement is considered as void. Clear? Yes, sir. Pretty easy paper, but little lengthy when you guys write. Understood? Okay. You got it right. Good.